Data on?
Well, it was about 2 a.m. I think you'll enjoy that. And they're like, sorry, everybody that fixes this is asleep. Well, we're in an elevator. There's got to be some resolution here. That's terrible. Of course, Paul's trying to, pry it open. Those little ham hands he has. Family okay? Yeah. What kind of hours your wife work with? More than you and me.
She usually gets home by 8. She can take Liam, put him in. I drag it home, time to feed him and bathe him.
Y'all got a live with.
His mom,
I guess she knows what she's doing.
yeah. Well, she screwed me up. This is her second shot.
So now she's redemption round.
Close to getting two checks. They gave them to me in December. One was dated January 1st. 40 grand, 30 grand. So I was thinking, man, this is good. And then they brought it in the paper. Gave 2.5 million. 70 grand sounds like all relative. Yeah. Starting calls for me.
Yeah, he should be. The Subcommittee on the Environment will now come to order. The Chair recognizes himself for 5 minutes for an opening statement. Today's hearing examines the impact of the EPA's New Source Review Air Permitting Program, commonly referred to as NSR. Congress created this pre-construction permitting program with the goal of protecting air quality by ensuring that the use of appropriate pollution control devices on new and modified sources of emissions such as power plants, factories, and industrial facilities. As you can imagine, the NSR permitting program reaches across several industry sectors and has far-reaching impacts on America's economy and global competitiveness. For these reasons, it is incredibly important for us to ensure that the pre-construction permitting program is working effectively and efficiently. Unfortunately, history shows that there are too many instances where a new source review program is anything but effective and efficient. As we will hear from many of our witnesses today, over time, the NSR program has become more costly and time-consuming, which not only slows economic growth, but also hinders the nation's ability to modernize infrastructure. Under the existing NSR program, it can take multiple years and millions of dollars to obtain the pre-construction air permits required to begin construction on a new facility. This significant time delay and cost burden makes it more difficult and less likely for owners to invest in new projects and facilities. Not only is the NSR process costly and time-consuming, it is also complex and uncertain. Right now on the EPA's website, there are nearly 700 posted guidance documents that an applicant may need to be aware of when seeking a pre-construction permit. Companies must hire teams of lawyers just to understand the requirements and processes established under the NSR program. The end result of this complexity is that companies are afraid of incorrectly interpreting NSR requirements and violating the rules, that they are hesitant to pursue projects that require an NSR pre-construction permit. In other words, the NSR program is holding back needed investment in the nation's infrastructure, industrial capacity, and manufacturing capabilities. One particularly frustrating effect of the NSR program is that it discourages owners from carrying out projects that would improve the environmental performance of their facilities. For example, if a company wants to perform efficiently upgrades to install new pollution control technology, they typically have to obtain a pre-construction permit through the NSR program. However, because the NSR program is so burdensome, many owners are choosing to avoid the NSR process and facility upgrades altogether and are instead continuing to operate older, less efficient, and dirtier facilities. Clearly, there are significant problems and shortcomings with how the NSR program is being carried out today. The goal of this hearing is to identify and understand the challenges connected to the NSR program so that we can begin considering potential reforms to improve the program. To assist our work, we will hear today from witnesses who can explain the challenges faced by manufacturers and industry seeking to expand operations. We will hear from state regulator who can explain the role NSR program plays in protecting local air quality, and we will also hear from NSR policy experts who can discuss options for how to reduce unnecessary NSR permitting burdens. I am confident that through targeted changes to the NSR program, we can not only reduce the unnecessary burden imposed upon industry, but also maintain and enhance the NSR's program's important protections for the environment and public health. And with that, I'd like to yield no, she's not here. So I will turn to the minority. Are you ready to go? I would like to recognize the ranking member of subcommittee, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair, and thank you to our witnesses for being here today. Today's hearing will examine EPA's new source review permitting program. As we have discussed on many occasions in this subcommittee, under the Clean Air Act, EPA is required to set health-based national ambient air quality standards, or NAAQS, for 6 criteria pollutants. As more medical and scientific evidence has come to light, NAAQS have been adjusted accordingly to ensure they continue to be protective of our health. Since the passage of the Clean Air Act, our nation has experienced a drastic reduction in these air pollutants, all while our economy has grown tremendously. It is beyond dispute that air pollution has serious health and economic consequences. When people are sick, hospitalized, and miss school or work, we are a less productive society. The new source review program plays an important role to ensure that new and modified major sources use the appropriate pollution controls to limit emissions of criteria pollutants. This includes the best available control technology in locations with relatively clean air, known as prevention of significant deterioration, to ensure these areas continue to maintain healthy levels of air quality. For areas in non-attainment of a NAAQS, this includes the lowest achievement emissions rate along with appropriate offsets from other existing sources. This is known as non-attainment new source review. The Clean Air Act has been successful because it is premised on making progress over time. We have made major strides in reducing pollution as our understanding of the health risks posed by dirty air has become more sophisticated. That is why I was pleased to see EPA's website recognize February as American Heart Month. EPA has some useful heart health statistics, such as heart disease and stroke are the 1st and 4th leading causes of death in the United States. Air pollution can affect heart health and can trigger heart attacks and strokes that cause disability and death. 1 in 3 American adults has heart or blood vessel disease and is at higher risk from air pollution. It is critical that we acknowledge and educate people on the role air pollution plays in exacerbating heart disease, asthma, and other respiratory illnesses. So while EPA's website has taken steps to connect the dots between air pollution and threats to Americans' health, the actions by Administrator Pruitt and Assistant Administrator Wareham have been troubling. On December 7th, Administrator Pruitt issued a memorandum with a new approach to implementation and enforcement of the new source review program. EPA will no longer review the permit applicant's emissions projections, nor will the agency enforce against an applicant that provides invalid estimates. In some cases, this lax attitude on enforcement will have consequences in downwind states, far away from the original permitting authority. And while not the subject of today's hearing, another data point from January 25th, Assistant Administrator Warren reversed EPA's longstanding once and always in policy for major source MACT requirements. Both decisions will result in greater air pollution. And the new source review task force seems to be little more than a brainstorming session on how to evade air pollution controls rather than actually building a public record on how the program might be improved. Progress over time means ensuring we don't backslide. And sadly, I believe the direction of this EPA will cause us to do just that. My district and many great towns and cities across this country were built by manufacturers. But when many of those facilities were built, we didn't fully understand the consequences of dirty air. We didn't know that 1 in 3 American adults has heart or blood vessel disease and is at higher risk from air pollution. We know better today. Our health and environmental safeguards should reflect that. We shouldn't have to ask our constituents to bear all the costs of air pollution, especially not when there are effective and well-understood pollution controls. I would urge EPA's leadership to stop going down this path and consider how to best improve and preserve air quality. So again, I thank the witnesses for being here and helping us better understand some of the potential changes to the new source review program. And with that, Mr. Chair, I yield back.
Gentleman yields back his time. Chair now recognizes Chairman of Full Committee, Mr. Walden from Oregon, for 5 minutes.
I thank the gentleman and appreciate the witnesses being here today. We look forward to your testimony. As we all know, the purpose of the Clean Air Act is, and I quote, to protect and enhance the quality of the nation's air resources, to promote the public health and welfare and the productive capacity of its population, close quote. So with today's hearing, we'll highlight the necessity to ensure the rules to protect and improve air quality promote both of these core objectives. Effective clean air regulation should allow the nation to continue to expand its manufacturing and industrial capacity, but these goals are undermined when regulatory requirements no longer reflect practical reality. As a result, American communities are deprived of both continued environmental improvements and economic prosperity. The new source review permitting process serves as a case in point. Permitting requirements under EPA's NSR program have evolved in complexity and confusion since the program began in the 1970s, and as a result, complex pre-construction planning requirements present unnecessary delays and impediments to the expansion of manufacturing and industrial facilities. As we will hear in the testimony today, the complexity of the NSR process, permitting time delays, and regulatory uncertainty create powerful incentives to forego needed project upgrades, even in areas that meet current air quality standards. And for other communities, NSR complexity raises costs and otherwise harms the prospects for economic expansion and increased environmental benefits. In fact, the burdens associated with NSR can lead to communities losing the emissions benefits offered by more efficient modern technologies. Prineville, Oregon, that's in my district, is home to data centers for Facebook and Apple. Recently, a proposed data center expansion ran headlong into a permitting issue because of potential backup generator emissions. A single air sampling location, just one, and restrictive air quality rules made it unclear whether or not the expansion could go forward. It was only after the city persuaded the EPA to add an additional sampling location that they were then able to resolve the issue. That instance involved hundreds of millions of dollars in investments and hundreds of construction jobs. Multiply that by the thousands of projects waiting to take off the ground, the nation around the nation in response to our reformed tax structure, and the urgency of addressing NSR problems becomes apparent. I would also say that when you're dealing with companies with the capital and intellectual capacity of Facebook and Apple, they're probably better positioned to challenge some of these issues. The witnesses today, you all bring a range of perspectives on the NSR permitting process. We appreciate your willingness to help us understand the challenges of the current process and what we can do to improve upon it. Our goal is to develop responsible, targeted reforms that will provide for economic growth while maintaining the environmental protections we all agree are important. Doing this will ultimately benefit all American workers and consumers. I know Ms. Blackburn was hoping to have a little time, but she is not here. So with that, I will yield back.
Gentleman yields back his time. Chair now recognizes the ranking member of the full committee, the gentleman from New Jersey, for 5 minutes.
Thank you, Mr. Chairman. We're here today to discuss one of the Clean Air Act's oldest and most debated programs, the New Source Review Program. It's based on a simple principle. Any new facility that emits pollutants should not increase local air pollution above levels that are safe to breathe. The NSR program ensures that we have growth in the economy and not in pollution. In December, Administrator Pruitt issued a memorandum altering longstanding NSR policy using an active case as justification for the change. The case was U.S. versus DTF Energy Company, or DTE Energy Company. And the December memo actually reads as if it were prepared by DTE's legal team. I can't say that comes as a complete shock to me, since Bill Wareham, the man Administrator Pruitt put in charge of the office that drafted the memo, was previously part of DTE's legal team. The new policy is as suspect as the process used to initiate it. It will gut enforcement of the NSR program to the benefit of certain companies at the expense of the public health and companies that have cleaned up their act. The 8-page memo lays out a policy that invites polluters to skirt the law and dump tons of harmful pollution on our communities. Essentially, it's a recipe instructing polluters how to cook the books and get out from under the need for a permit under the NSR program. And this is certainly not a perfect program, but it has helped reduce harmful air pollution and improve public health, especially for people living in the communities close to these facilities. All of these gains will erode rapidly if we stay on the course this administration is following. Too many old facilities have already used loopholes to game the system and avoid cleaning up the pollution. Certainly there are challenges for those existing facilities, but the Clean Air Act never intended for them to be exempt from the NSR program forever. Also, it's important to remember that pollution control is a zero-sum game. Therefore, under Administrator Pruitt's NSR scheme, states and localities will have to make those that have played by the rules achieve greater pollution reduction in order to offset the excess pollution created by businesses that EPA is essentially allowing to go unregulated. And that's particularly outrageous to those of us who represent downwind states. We're tired of having to compensate for the lack of pollution control in neighboring states. EPA should not be making life easier for polluters. The agency should do its job and ensure that lax implementation and enforcement in one state doesn't burden others. Now, Republicans argue that we need to ease the NSR program to expand manufacturing and infrastructure, but new manufacturing facilities aren't being held back by clean air requirements. Weakening the Clean Air Act is not going to create jobs. The fact is that the so-called NSR program improvements being suggested today by my Republican friends are not new ideas. They're just a bunch of toxic old policies bundled up in a heart-shaped box as a Valentine's Day present to polluters. Industry has been trying to get out from under this program for a long time, and it looks like Scott Pruitt and Republicans are working hard to try to grant their wish. But make no mistake, the Valentine's Day gift from Pruitt and Republicans gives polluters all the roses and sticks the public with the thorns. We should reject these policies that will harm the public health. Unless someone else wants my time on my side, I'll yield back, Mr. Chairman.
Gentleman yields back the balance of his time. Do you have a new writer?
I don't know. I thought it was pretty good myself.
We now conclude with members' opening statements. The chair would like to remind members that pursuant to committee rules, all members' opening statements will be made part of the record. We want to thank all our witnesses for being here today and taking the time to testify before the subcommittee. Today's witnesses will have the opportunity to give opening statements, followed by a round of questions from the members. Our witnesses panels for today's hearing will include from my left to right, Mr. Stuart Spencer, who's Associate Director, Office of Air Quality, Arkansas Department of Environmental Quality, testifying on behalf of the Association of Air Pollution Control Agencies. Mr. Kevin Sunday, Director of Government Affairs, Pennsylvania Chamber of Commerce, Business and Industry. Mr. Paul Noe, Vice President, Public Policy, American Forest and Paper Association and American Wood Council. Emily Hammond, Glenn Earl Weston Research Professor of Law, the George Washington University Law School. John Walke, Clean Air Director, Natural Resources Defense Council, and a friend of ours from years past, Jeffrey Homestead, who is a partner at Bracewell. So with that, we'd like to begin our testimony, and we will begin with Mr. Spencer. Your entire record is in the file. You have 5 minutes, and you can begin.
Thank you. Good afternoon, Chairman Shimkus, Ranking Member Tonko, and distinguished members of the subcommittee. I appreciate the invitation to join you today to discuss the important issue of news source review reform. I'm here in two capacities. First, I'm here as an Associate Director of the Arkansas Department of Environmental Quality. Our Office of Air Quality staff includes epidemiologists, engineers, ecologists, chemists, biologists, a meteorologist, and a lawyer in the primary branches of compliance, permits, policy and planning, and asbestos and enforcement. Our primary mission is to protect and improve air quality in Arkansas while fostering responsible economic expansion opportunities. Second, I'm here as the president of the Association of Air Pollution Control Agencies, or APCA. APCA is a consensus-driven organization comprised of 45 state and local air agencies. The APCA Board of Directors is made up of the air directors from our 20 geographically diverse member states, including states with representation on this subcommittee. As APCA's president, I serve on the board of directors, along with air directors from states as diverse as Wyoming, Maine, South Carolina, and Arizona. And despite the miles between our state borders, we have common goals and missions. Today, I'll be addressing a few common themes in regard to NSR reform. The first theme is practical application. Environmental regulations should encourage necessary repair and replacement projects and should incentivize projects that improve the safety of operations, increase energy efficiency, or reduce the emissions of regulated air pollutants. The second theme is clarity. This includes removing undefined terms and exemptions, such as routine maintenance and non-routine modification, from the NSR rules and guidance and replacing them with clear definitions. A prime example would also be refining the term modification to truly mean a substantial change. An ambiguous or muddy rule inhibits planning due to its lack of certainty and therefore stifles growth and innovation. This leads me to my final theme, modernization. NSR is outdated and cumbersome. The documents that comprise the NSR rules and the guidance take up at least 2 file boxes if printed out in hard copy form. The time to reform was yesterday, so I'm glad we're having this conversation today. With those themes in mind, I'll speak first as the Associate Director of ADQ. The Office of Air Quality implements all programs delegated by EPA Region 6 to the state of Arkansas. Under the leadership of one of your former colleagues and now Governor of Arkansas, Asa Hutchinson, and ADQ Director Becky Keogh, Arkansas has committed to protective permitting. This practice is essential to achieving our goals of maintaining our status as the natural state, protecting public health and the environment in our communities, and promoting and sustaining economic growth. The Arkansas NSR program follows the federal program. ADQ believes that the NSR rules should be clear and concise to allow companies to achieve compliance and ensure that both ADQ and our regulated community have a well-defined understanding of what is required by the program. Arkansas believes that changes to the NSR program would support its efforts to ensure that our regulated community and the companies in our communities are in compliance with the rules and do not become subject to enforcement actions based on rule interpretations that are either not well defined or continue to evolve. For these reasons, we appreciate that EPA intends to tackle NSR reform again. The 2002 NSR reform rule was helpful, but it did not go far enough to clarify the program and provide certainty to regulators and the regulated community. So based on these points that I've made, any efforts to modernize and reform NSR, particularly the upcoming EPA-directed NSR task form discussions, should address the following issues. Number one, revise the emission increase test under NSR to match the hourly test under New Source Performance Standards, or NSPS program. This would eliminate and streamline many of the issues with the current program. Many of the other changes could be avoided or simplified if NSR applicability was based on an increase in maximum achievable emission rates rather than annual tons. Next, clarify the factors to be considered in determining whether a project is a routine maintenance, repair, or replacement activity. Next, create an exemption from NSR for efficiency projects. The current program is a disincentive to companies undertaking projects to make their operations more efficient. Next, codify the information in EPA Administrator Scott Pruitt's December 7th, 2018 memo that EPA will not second-guess a facility's emissions projections and clearly identify the circumstances when an emissions projection will be subject to review. Next, clarify the definition of a source in order to ensure that geographically separate sources are not artificially combined or aggregated to create a single major source for NSR purposes. And finally, clearly identify what types of projects should be considered as changes in the method of operation. Thank you for your time again today, and I'm available to answer any questions upon request. Thank you.
Thank you. Excellent. I now turn to Mr. Kevin Sunday. You're recognized for 5 minutes.
Good afternoon, Mr. Shimkus, Mr. Tonko, and members of this committee. My name is Kevin Sunday, Director of Government Affairs with the Pennsylvania Chamber of Business and Industry. It's an honor to appear before you today to discuss the challenges our members have had when it comes to complying with new source review requirements. Our nearly 10,000 member companies are of all sizes and across all industry sectors, and we as an organization seek stewardship of our nation's land, air, and water, and we seek to provide thoughtful and balanced ways in which we can continue to reduce our environmental impacts and grow the economy. Thanks to tax reform and the prolific supply of our natural resources in nuclear, coal, gas, oil, and renewables, we have before us a generational opportunity to invest in our workforces, our infrastructure, and our future. And we applaud the members of the House of Representatives and the United States Senate who took a bold stand for growth and sent the Tax Cut and Jobs Act to the President's desk for his signature last year. And we thank our Senator Pat Toomey for his leadership in getting that bill through the Senate. In the short time since that bill was enacted, employers across the country have announced plans to increase hiring and wages. And it's expected that in the near term, consumer spending and economic growth will increase considerably, as much as 4% on an annualized basis, according to the Atlanta Fed. And as the economy grows, capital is going to be repatriated and rates on employers come down. Manufacturers and businesses have a generational opportunity to secure a global competitive advantage by reinvesting into their facilities, enhancing their sustainability profiles, and expand to capture a share of the growing economy, provided, of course, that regulatory obligations do not present unnecessary hurdles. What energy means to Pennsylvania and the region is significant. We're part of an endeavor called Forge the Future, which forecasts $60 billion in state GDP and 100,000 new jobs because of energy assets. The Appalachian region at large, including Pennsylvania, Ohio, West Virginia, and Kentucky, could become a petrochemical and plastics manufacturing hub, and according to the American Chemistry Council, more than $28 billion in economic expansion and more than 100,000 new jobs could be created should the region capitalize on an ethane storage project and secure the construction and operation of several petrochemical plants. However, these projects, too, must wind through the permitting process to become reality. Our manufacturers in Pennsylvania have reported that the current NSR process is an impediment to investing in the efficiency of their operations and improve their ability to compete abroad. Because of the costs associated with crossing NSR thresholds, companies have shelved projects that would have reduced their emissions and their operating costs. Disputes between state and federal regulators over the interpretation and application of regulatory criteria have resulted in sizable legal and engineering costs and left projects in limbo for months, if not years. Lenders will not sign off on financing until the revolving door of lawsuits from third-party groups over the perpetually changing universe of BACT and layer controls stops spinning. Economic growth and environmental progress depend upon a well-functioning and rational regulatory system, and the NSR program, as it's being administered, shows signs of being neither. From a land use perspective alone, it's illogical that we would have a regulatory program that would encourage building entirely new facilities, oftentimes outside the U.S., when existing plants are being mothballed and retired that could have been upgraded. And how much has the closure of large-scale manufacturers in this country led to the flat electricity demand that has so troubled the power generation and utility sectors? So that's why we applaud EPA Administrator Scott Pruitt and his team at EPA for the December 7th memo that clarifies how NSR requirements should be interpreted and applied. That's a crucial first step to reform of the program, and we look forward to additional progress on that front. The National Federation of Independent Businesses yesterday came out and said a record number of small businesses believe now is a good time to expand. We believe we can ill afford to waste this opportunity in front of us by leaving up barriers to growth. We have the opportunity to make our regulatory process more efficient, allow our companies to invest and reduce their environmental footprint, and waste less of our natural resources. And if we don't capitalize on that opportunity, that's a failure. It's bad for business and it's bad for the environment. Instead, let us pursue stewardship of our natural resources and secure economic growth in a thoughtful, responsible manner, and that starts with NSR reform. Thank you.
The chair thanks you. The chair now recognizes Mr. Paul Noe. You're recognized for 5 minutes.
Chairman Shimkus, Ranking Member Tonko, and distinguished members of the committee, on behalf of the American Forest and Paper Association and the American Wood Council, I want to thank you for the opportunity to be here to discuss the challenges posed by EPA's NSR program for the forest products industry and to provide our perspectives on how it can be improved. This is consistent with the twin purposes of the Clean Air Act, which is to promote public health and welfare as well as the productive capacity of our nation. Unfortunately, NSR is an outdated, inefficient, and slow regulatory approach that currently just doesn't work very well for existing sources, and it's impeding modernization and growth in the U.S. manufacturing sector. It just doesn't make sense to discourage upgrading plants already subject to a myriad of other regulatory requirements or to block beneficial projects using best controls simply due to unrealistic air quality modeling and assumptions. Our country has made great strides in improving air quality, largely under other programs. To borrow from my friend and former EPA General Counsel Don Elliott when he testified before Congress 15 years ago on the need for NSR reform, quote, NSR is slow, costly, and ineffective, and those are the kindest things that one can say about it. It is the least successful of all the programs under the Clean Air Act. The reality is that energy efficiency and modernization projects for existing sources are delayed, modified, or thwarted by complex NSR interpretations that have accumulated and evolved over time. The program requires expensive but unrealistic air modeling that frequently delays projects and can cost $100,000 or more to complete. Unreasonable permitting delays tie up investment capital and undermine the economic benefits from expansion projects. There are many ways EPA could improve the permit process, but let me focus on 2 key points. First, consistent with the statute, EPA should focus the NSR program on larger projects that really have a greater potential to impact air quality. Changing the NSR applicability criteria could reduce unnecessary workload on permitting agencies and create business certainty and positive incentives without jeopardizing air quality. For example, currently the NSR regulations use a 2-step calculation process to determine if a project is subject to NSR. The emissions increases from a project are calculated first to see if they are significant before any decreases are subtracted. This step 1, then step 2 analysis is complicated, expensive, and time-consuming. By simply allowing increases and decreases to be netted, projects with emissions below significant levels could proceed. Second, once a project truly does trigger a higher level of scrutiny, EPA ought to use realistic assumptions and analytic tools, including probabilistic air quality modeling approaches. This is needed now more than ever because there is little room for error. This is because in recent years, EPA has lowered the national ambient air quality standards close to background levels. This has left little room for permits, even in attainment areas. In the past, when NAAQS for PM or SO2 or nitrogen dioxide were higher, if you looked at that versus the ambient level and emissions from the nearby sources and the facilities exposures, there was enough room, or headroom as we call it, for a permit. The problem is seriously exacerbated by many of EPA's current policy approaches and modeling tools which significantly overpredict impacts from facilities, especially when a series of unrealistic assumptions are compounded. So it's critical that the modeling results reflect the reality of local air quality. For example, EPA's current modeling guidelines have an expansive interpretation of where the general public must be protected from nearby plant emissions. Rather than focusing on where people actually are, It is assumed that ambient air is anywhere a person theoretically could be, such as by illegally trespassing at the facility or where the general public in reality could not be, such as standing on a railroad or a road that runs through the facility. Overly conservative modeling analysis can lead to unverifiable and non-existent concentration estimates that cause costly changes or cancellations of beneficial projects, even though real-world exposure of the general public around these locations is minimal, improbable, or even impossible. Therefore, EPA should issue new guidance to update its policies for placing receptors considering natural, man-made, or jurisdictional barriers. Although forest products mills typically are located in attainment areas with better quality, they face problems as soon as NACs are issued because they're immediately effective, and EPA has compounded the confusion and delay by not providing implementation and modeling guidance until after the NACs are issued. I don't believe Congress intended this confusion and delay when it enacted the act, and I believe the U.S. is the best place in the world for a robust manufacturing sector. We have the best workers in the world. We have creative entrepreneurs and innovators. We have abundant resources. We have a strong free market democracy, and we have regulatory agencies that are capable of leading the world on sustainable regulation. Thank you, Mr. Chairman.
Gentleman's time expired. Chair now recognizes Emily Hammond. You're recognized for 5 minutes.
Thank you, Chairman Shimkus, Ranking Member Tonko, and distinguished members of the subcommittee. 1 year ago, almost to the day, I testified before this subcommittee about the many health and environmental benefits of clean air protections, and I cautioned against efforts to roll back progress achieved over decades of hard work. Today, I urge you to scrutinize recent actions by EPA that amount to nothing short of an abnegation of the agency's statutory responsibilities. And I emphasize once more that human lives and our economy are at stake. The Clean Air Act is a technical and complex statute, but two of its basic policies are straightforward. First, it is meant to clean up dirty air. Second, it aims to keep clean air clean. By keeping in mind these first principles, it's easy to see what's wrong with EPA's current approach. New source review makes sure that new or modified sources of air pollution use the right technology so that in areas where poor air quality harms human health, we can improve over time. And in areas where air quality meets human health standards, new source review guards against creating a new public health problem with new uncontrolled air pollution. But on December 7th of this past year, the same day that EPA Administrator Scott Pruitt testified to this subcommittee that EPA should not issue guidance documents, he issued a guidance document that promises to polluters that EPA won't check the work of those major polluters when they decide whether new source review is necessary. This approach opens a gaping hole in the statutory design, and it violates fundamental principles of good governance and legitimacy. The President, Administrator Pruitt, and members of Congress have all spoken against the perils of overreach when agencies make major policies through non-democratic procedures. Yet the December 7th guidance does just that. When an agency adopts a policy so blatantly contrary to its mandate and does so without any public input, that action lacks legitimacy. In the words of the Supreme Court in Heckler versus Cheney, the agency has consciously and expressly adopted a general policy that is so extreme as to amount to an abdication of its statutory responsibilities. This institution should hold EPA to task, not give it cover to make our air dirtier. And what is at stake? The lives of people across our country and the benefits of economic growth. You'll hear a lot from industry about the costs of clean air protections and the supposed impediments clean air poses to economic growth. But they won't tell you about the attendant benefits because the numbers are so compelling. Between 1970 and 2011, aggregate emissions of air pollutants dropped 68%, while the U.S. gross domestic product increased 212%. During that same period, private sector jobs increased by 88%. Our population has increased, we have used more energy, we have built more infrastructure, all while improving our environment. Consider as well that major regulations issued by EPA undergo a rigorous cost-benefit analysis. EPA is required to follow Office of Management and Budget accounting principles and assess both the costs and the benefits of regulations. Many researchers have concluded that these constrained analyses vastly understate the benefits of environmental regulations, so the values I'm about to describe should be understood as very conservative. Even with this caveat, the results are compelling. A 2011 peer-reviewed study showed that the benefits of the 1990 Clean Air Act amendments and implementing regulations exceed the costs by a factor of more than 30 to 1. The 2011 study also revealed that EPA's Clean Air Act rules saved over 164,000 lives in 2010 and are projected to save 237,000 lives in 2020. These same rules saved millions of days of lost work and missed school and will continue to do so. Further, since EPA began regulating lead as a criteria pollutant under the NAAQS program, the median concentration of lead in the blood of children between 1 and 5 years old has decreased 93%. These numbers speak for themselves, and they demonstrate that those who would roll back clean air protections have set up a false choice. Clean air and economic growth do indeed go hand in hand. Thank you.
Chair thanks the gentlelady, and now the chair recognizes, and I mispronounced the last name, Mr. Walk. You're recognized for 5 minutes. I apologize for that.
You got my first name right, so that's, thank you. Thank you, Chairman Shimkus, Ranking Member Tonko, and distinguished members. My name is John Walk, and I am Clean Air Director and a Senior Attorney for the Natural Resources Defense Council. Any so-called reform to the Clean Air Act's new source review program first should answer one simple question: will it let industry pollute more? In my experience, unfortunately, the answer to that question is usually yes. That is the case for changes to new source review safeguards that industry commenters are seeking from the Trump administration. That is also the case for changes sought in testimony by other witnesses at today's hearing, apart from Professor Hammond's. Many of the requested changes would let industry pollute more by significantly higher amounts, and in the process evade pollution controls and pollution offsets. Insufficient political attention and concern are being given to the problems with attacks on clean air safeguards. In a 2017 Gallup poll, 67% of Americans favor setting higher emission standards for industry. In that same poll, 69% of Americans favor stronger enforcement of federal environmental regulations. New Source Review is a Clean Air Act pre-construction permitting program that imposes its cleanup requirements only when industrial facilities significantly increase air pollution. I urge you to remember that pollution increase trigger during today's hearing. Attempts to evade NSR applicability translate into the ability to increase air pollution significantly without control. Take an evasion that would allow huge air pollution increases reflected in two bills referred to this committee, H.R. 3127 and H.R. 3128. Several witnesses endorse the bill and the approach contained therein, which would allow huge air pollution increases so long as a source did not increase its capacity to pollute, only by exceeding an extraordinarily high maximum hourly emissions rate plucked from its past history. One of the problems here is comparable to saying police should never find drivers to be speeding if they don't exceed the maximum speed they have ever driven. A second problem is even worse. By weakening the law so extremely to ask only whether a polluting facility exceeded its maximum capacity to pollute, this concept would allow massive, enormous increases in actual emissions of harmful air pollution in the real world. Americans care about increases in actual pollution that worsens air quality and harms their health, not whether a plant exceeds its polluting capacity. For the parents of a child being rushed to the ER due to an asthma attack caused by massive pollution increases from a nearby plant, it is no solace to tell them that the higher pollution levels that choked their daughter's breathing did not result from the plant exceeding its maximum hourly emission rate. How bad could these pollution increases be? Well, under the Bush administration, when Mr. Homestead worked there, EPA's Enforcement Office calculated the weakening effect of a maximum hourly emissions rate approach. In just one power plant example, the plant increased its toxic sulfur dioxide pollution by 13,000 tons per year without exceeding this maximum rate. That is 327 times higher than the level that the law considers significant and subject to control today. My testimony identifies an astonishing number of coal-burning power plants that still lack modern air pollution controls today, or that are uncontrolled. And these two bills and the approaches sought by some of the members of this panel would make that even worse by allowing emissions increases of thousands and even increases in excess of 10,000 tons. No acceptable NSR reform should give an affirmative answer to the question posed at the top of this testimony: will it let industry pollute more? This committee should reject any appeals for reform that would let industries pollute more by significantly higher amounts, and in the process evade air pollution controls and pollution offsets in areas already experiencing unsafe air quality. Americans deserve better. Thank you.
Chair, thanks, gentlemen. Chair now recognizes Mr. Homestead for 5 minutes. Welcome back.
Thank you. Thank you for inviting me to be here today. As some of you know, for almost 30 years, I focused my professional career on the Clean Air Act as a White House staffer, as head of the EPA Air Office, and as an attorney in private practice. I think even that my good friend John Walk here would concede that I know a lot about the various programs that apply to major manufacturing and energy facilities. But some of you may not be quite so aware. You might be surprised to know that there are many different Clean Air Act programs that regulate the very same pollutants from the very same facilities. For example, SO2 and NOx emissions from coal-fired power plants, which seem to be the pollutants of greatest concern. These pollutants from these plants are regulated under at least 14 different Clean Air Act programs. Yes, 14. The Acid Rain Program, the NOx SIP Call, MATS, NSPS, Regional Haze Program, the 110A2D Good Neighbor Provision, Section 126, CASPER, BART, the SO2 NACs, the NO2 NACs, the Ozone NACs, the PM 2.5 NACs, and NSR. If I'd said the full names of these programs instead of the acronyms, I would have used up all of my time. Over the last 25 years, serious regulators and researchers have learned that good regulatory design makes an enormous difference, and they will tell you that of these programs, some of them are much more effective than others. Because of all of the overlapping regulatory programs, our society, you and I, and all the people you represent, are paying much more than we need to pay for preserving and improving air quality. If we take advantage of the lessons that we have learned over the last 25 years and we use the most effective approaches for reducing air pollution, we can achieve the same air quality goals that we have today at a much lower cost. Today, we are talking about just one Clean Air Act program. As the name implies, New Source Review, this is an important program for regulating emissions from new sources. But over the last 20 years, as EPA has tried to expand it to capture as many existing sources as possible, NSR has become a convoluted, burdensome, and completely unnecessary mess. As someone who has worked on Clean Air Act policy for almost 3 decades, I can say with confidence that the NSR program, as it applies to existing facilities, is the least successful and most counterproductive of the dozens of programs created under the Clean Air Act. To the extent it provides environmental benefits, those same benefits can be preserved by reforming the program in a thoughtful way and by relying on other much more effective programs that regulate the same pollutants from the same facilities. The critique offered by my friend here from NRDC is more than a bit over the top. I did a word search last night and found 10 different places in his testimony where he says that the reforms being proposed by Congressman Griffith would allow, quote, massive or enormous increases in harmful air pollution. 15 places where he says the bills would allow facilities to evade pollution controls, and 11 places where he uses the words reckless or irresponsible to refer to the proposed reforms. Statements like this are just plain silly, and they are demonstrably untrue. They ignore the fact that every single existing facility that is covered by the NSR program is also regulated by multiple other Clean Air Act programs. In the case of coal-fired power plants, by as many as 13 other programs that regulate the very same pollutants. even, and I can guarantee you this, even if the NSR program disappeared completely tomorrow, there would not be a massive increase in air pollution. In fact, there would not be any increase in air pollution at all, and we would see, because of the many other programs that regulate the same pollutants from the same facilities, air pollution would continue to decrease as it has since 1990. As I explained in my written statement, the reforms being proposed by Mr. Griffith would simply reintroduce some common sense into the NSR program and make sure that it does what it was intended to do, ensure that when a new industrial facility is built or an existing facility is significantly expanded, modern pollution controls will be used to minimize its emissions, and to ensure that the NSR program does not make it hard for companies to keep their facilities in good working order, and where possible to reduce the operating costs of these facilities by making them more efficient. Again, I thank you for inviting me here today. I hope we can have a serious discussion about Clean Air Act policy, and I look forward to answering any questions that you might have.
And I thank the gentleman for his testimony, and thank you all, and you all were very punctual to the dot almost, and that's going to be helpful. Recognize myself 5 minutes for the opening round of questions. And Mr. Holmes, you answered my question about how many different tools are there out there, so I don't need to ask that one. Mr. Spencer, first, just to clarify your role for the record, you are the responsible authority in your state for implementing air quality standards, which includes new source review permitting. Is that correct?
Correct, yes.
And to perform your job, you rely upon engineers, scientists, and an attorney, I think you said in your...
I wanted to clarify, yes, we do have one in-house at the Office of Air Quality.
But you also have engineers and scientists and...
Epidemiologists, meteorologists, chemists, biologists.
Given your experience, do you believe the new source review reforms you describe in your testimony will create a gap in protection or will result in declining air quality standards for your state? And let me add will it allow industry to pollute more?
No and no. And I would like to acknowledge something that Mr. Homestead said. It's important to recognize the projects or the programs that are working in tandem with each other. We have several different, we have our NAC SIPs that are state implementation plans that we prepare and submit to EPA that are that indicate and acknowledge that we'll be protective of those individual criteria pollutants. We have our regional haze plans that we submit, and as Mr. Homestead indicated, those are specific to controlling particularly NOx, SO2, and PM 2.5. So there are a number of different programs which we implement that stack upon each other to ensure that we have protected programs.
So let me go to Mr. Noe. I was struck by the example you shared where it took, and I use this many times, this example when I've talked about this program for 20 years now. When it took a paper mill owner 18 months to obtain a new source review pre-construction permit for a project to replace 2 older, inefficient boilers with a single, larger, energy-efficient boiler which uses less energy. And I want to underline this because it's in response to one of the other panelist statements, did not result in an emissions increase. So to you, Mr. Noe, does it really make sense that an owner has to receive a pre-construction permit just to install newer, more environmentally beneficial technology, especially considering how long it takes to obtain a permit?
What we, Mr. Chairman, is for projects that are going to have decreases associated as well as increases, just net the increases and decreases at the start. So if there's not really a significant net increase, why go through this onerous process and delay? If I could, I would like to give you another example where a company was going to do something that would decrease emissions, but because of this way in which EPA does the math, this 2-step process, it was slowed down, and you basically took longer time to get less emissions. This was a wood products facility that essentially wanted to use better emissions control, reroute its exhaust from a unit to better emissions control. It had to do a $100,000 study. There was months of delay. The agency ultimately concluded this was a good thing, but there was a delay in getting a beneficial project done, more emissions because of the delay from NSR.
And I think your response was following up on my second question about affecting the development of and implementation of newer and cleaner technology, so I don't need to ask that. Let me go to you all, if I have time. A report conducted by Resources for the Future showed that from 2002 to 2014, the average time to obtain a prevention of significant deterioration NSR permit throughout the country was 420 days. More specifically, in certain states during that time period, the average permit time was 770 days. Do you think, and if you can get yes or no or as short as possible, do you think that it is reasonable for an owner to wait 1 or 2 years on average just to obtain a pre-construction permit? Mr. Spencer?
No, I can say that the permit backlog and permit issuance timeframes were very important to our administration, to this current administration, and we've seen that. A dramatic reduction in that. Yes, so no, that's not a reasonable timeframe.
Thank you. Mr. Sunday?
No.
Mr. Noy?
Agreed.
Ms. Hammond?
I agree that efficiency is important at an agency, but I think taking the time is worth it to do it right.
Okay, Mr. Walk?
I'm not here defending delays. I'm opposing pollution increases.
Okay.
So,
Mr.
no.
Homestead?
There's no reason for it to take that long.
Thank you very much. My time's expired. Chair now recognizes the ranking member of the subcommittee, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair. New York has done a lot to clean up air pollution in our state, but we're still facing problems that blow in from the west. We need the New Source Review Program to work. We have to make progress on air quality together as a nation because cleaning up the air is a common responsibility, and we all have to do our part. Mr. Walk, I am very concerned about the implications of Administrator Pruitt's December 7th memo for state enforcement of the New Source Review Program. I have a number of questions for you related to that memo. In your experience, both as an EPA employee and as a representative for various interests on clean air issues, would you say that it is usual or unusual for the administrator of EPA to issue a memo that announces the agency's intent not to enforce a statute, regulation, or other legal requirement?
Extraordinary, and I've never seen it before.
So we go with unusual there. I have the 1984 Enforcement Office's memo related to issuance of assurances of no enforcement that you mentioned in your testimony. To your knowledge, has the policy in this 1984 memo, issued during President Reagan's administration, ever been rescinded or replaced?
No, it has not.
Are there provisions of the Clean Air Act or within the NSR regulations that expressly provide EPA with discretion to not enforce the requirement for a facility to provide credible estimates of their projected actual emissions in the NSR program?
No, and to the contrary, Mr. Pruitt contravened EPA regulations.
Is there any credible argument that loosening the criteria for estimating projected actual emissions or foregoing enforcement of this NSR regulation would be in the public interest and therefore justify issuing an assurance of no enforcement as discussed in this memo?
None whatsoever. Those emissions increases are what harm the public, and Mr. Pruitt has granted amnesty to industries that get it wrong, including badly wrong.
Administrator Pruitt has made much of his dedication to cooperative federalism, but this memo appears to do the opposite. Doesn't EPA's declaration that the agency will not pursue enforcement in these situations undercut states that want to enforce new source review standards?
Yes, many states will choose not to grant amnesty, and the last paragraph of the memo is really coercive federalism, threatening states that don't buckle under to withdraw their program approval. Again, it's very unusual.
Thank you. Your written testimony refers to a cryptic warning in the memo to states to toe the line. Would you elaborate on that, please?
Sure. So states administer the NSR program approved by EPA. And states don't have to follow EPA's decisions to grant enforcement discretion or, in this case, outright amnesty across the board. Mr. Pruitt's memo seems to anticipate that and says in the very final paragraph, and what's not even a very subtle veiled threat, that EPA has the ability to withdraw its approval from states that don't conform to the understanding of the program that EPA has. In a memo like this is clearly a threat of coercive federalism to remove approval from states that don't follow this amnesty approach.
Thank you. As administrator of this agency, Mr. Pruitt is supposed to uphold and enforce the law not subvert it. This program is supposed to clean up the air and bring older facilities up to modern pollution standards. The people that I represent need a functioning program. For us, cooperative federalism means that EPA is a partner in enforcement, not a partner in sidestepping the law and creating more pollution. Ms. Hammond, is there anything you want to add about the December 7th memo? Do you think if a polluter believes EPA will not check their work, it incentivizes applicants to underestimate their emissions projections?
Absolutely. It incentivizes the kind of gaming that we've seen throughout the entire history of this program. Over and over again, we see polluting industry, especially old, dirty coal, looking for loopholes, and this just opens that wider.
EPA's leaders often speak about the rule of law. That phrase takes an outsized role in the EPA's latest budget request. For Mr. Walk or Ms. Hammond, can you help us understand how EPA is upholding its rule of law commitment by shirking its responsibilities to enforce the Clean Air Act as outlined in the Administrator's December 7th memo?
Well, the President's budget now twice has proposed historically high cuts to EPA's enforcement program. Thankfully, Congress did not follow suit first time. I hope they will not this time. But what we have seen is an enforcement amnesty memo issued by the administrator himself that does not contain the name of any enforcement official on it. And as I detail in my testimony, there's some very serious concerns about the process that resulted in that amnesty.
And Ms. Hammond, anything?
Yes, just the further point that when an agency uses a guidance document to set binding policy, that evades the rule of law set forth in the Administrative Procedure Act. So we have that further problem as well.
Thank you. And Mr. Chair, I yield back, and thank you for your
Gentleman yields back his time. Chair now recognizes the Vice Chair of the Subcommittee, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman. I've been listening to testimony about this for now 7 years in Congress, and I think one of the conclusions I'm hoping we will come to is that the system, something's broken, because we're hearing some strong pushback from both sides. But I feel like a couple of you up there are unwilling to recognize that the system may need some modification. Is that fair to say, Mr. Wong?
No, sir.
You don't think it needs modification?
We're happy to discuss modifications that don't result in pollution increases, but that's what's
No
before
one's
this
talking
committee.
about increasing pollution on it.
I was answering your question,
That's what I just,
Congressman.
thank you on that. But, you know, I just feel that in many respects, the previous administrations have used, have weaponized the EPA's rule on NSR. And it's delayed, caused grief and aggregate. I spent my career in the engineering field, and many of it was in power plants, getting these permits, and I saw the delay, and the costs that were associated with those. And it's unnecessary. But I believe the intent was to try to slow walk the project so it didn't happen. So I'm first trying to recognize or get people to recognize the system. It's broken. It needs modification. We've been talking about, I think, Mr. Homestead, you said 15 years ago they were talking about making modifications to it. I don't know why we haven't during this. Is this just because we got people with their head in the sand? There's a problem here associated with this issue. And we need to have an adult conversation instead of saying no and trying to focus on a distraction that is the implosion. None of us in the engineering field or in the energy generation want to have this problem or increase emissions. But I'm afraid that what's going to happen is that we're going to close down more and more of our power plants, and as a result, with this delay and the fear of the unknown of our power plants, and we're going to reach into that issue that we've been talking about for now the last 2 years, has been about grid reliability and resiliency. When we have more and more, since the polar vortex of 2014, we've had 82 coal-fired power plants shut down. I know during this last winter, that many of our gas and coal-fired power plants were under advisory about that there was maybe a shutdown because of the lack of supply, particularly on gas. So I'm very concerned that we're continuing to focus on something where we should be able to cooperate and get something accomplished. So, Mr. Homestead, I've seen you just be very frustrated with this. You and I have had numbers of conversations about this. Can you give us some direction or advice? Because I applaud what Morgan Griffith's trying to do, is to have an adult conversation and address this issue. So Mr. Olmsted, do you have some thoughts about how, because I thought Mr. Spencer laid out a good plan. I thought Sunday did as well on that. But what's your perspective? What should we be doing to resolve the differences?
I think we should just be having an honest conversation about how all the Clean Air Act programs work together. I can't tell you how many times someone who's criticized a reform says that, you know, you're tearing at the heart of the Clean Air Act. As far as I know, the Clean Air Act must have 30 different hearts, because no matter what you try to reform, you're tearing at the heart of the Clean Air Act. Look, air pollution control is enormously important. The benefits of controlling air pollution are very significant. No one is talking about increasing pollution. There's no such thing as a massive increase that would occur even if we eliminated. Come on, let's have a serious conversation about this. And that's the frustrating part. Let's be honest with each other about how these programs work and how some of them don't.
Thank you. Speaker, or Chairman, I yield back.
Gentleman yields back his time. Chair now recognizes the ranking member, full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. My questions are of Mr. Walk, and I'm going to continue where my colleague, Representative Tonko, left off. I have also serious concerns about Administrator Pruitt's December 7th memo. In your written testimony, you discuss a number of concerns with the memo, and I want to explore one that you did not mention in your written testimony. I understand that several circuit courts have now rendered decisions that limit EPA's authority to enforce new source review violations by upholding a statute of limitation of 5 years from the time the first violation occurs. Is that correct, yes or no?
Yes.
The December 7th memo states that EPA will not take enforcement actions against any facility operator in relation to pre-construction permit requirements under the new source review program, and these requirements include estimating projected actual emissions, determining whether they need a permit or not, and any other actions that are required before a construction project is initiated and completed. Administrator Pruitt justifies this in part by initiating a policy that defers consideration of enforcement actions until the agency sees the actual emissions, quote, during the 5 or 10-year record-keeping or reporting period after, unquote, the project in question has been completed and the facility resumes operation. So, Mr. Walk, am I correct in my concern that deferring enforcement to this post-construction period places any enforcement action past the 5-year statute of limitations being upheld by the circuit courts? Again, yes or no?
Absolutely, yes, you are right to be concerned.
Thank you. So it appears that Administrator Pruitt has ensured that the agency will never act because the time period for action designated in the memo will always be beyond the statute of limitations. Any action taken by the agency deferred until this time period would very likely be overturned by the courts. So, Mr. Walk, again, do I have that right, yes or no?
100% right.
Okay. It doesn't seem likely to me that these circuit court decisions would be unknown or overlooked by the administrator or by Mr. Wareham, the Air Office Chief, who came on board at the agency about 1 month before this memo appeared. What do you think about that? That's not yes or no.
I can guarantee you Mr. Wareham is aware of those cases.
Okay. So the next thing is, look, the bottom line is the policy Mr. Pruitt is pushing in the December 7th memo is inconsistent with the law, in my opinion, and clearly will allow any facility owner that wants to get around the NSR program to do so. And that's terrible public policy and will commit us to many more tons of harmful pollution. And in my opinion, it should be rescinded immediately. So I just have a few more questions on this memo and its relationship to the policy memo from the Reagan administration mentioned by Mr. Tonko. Hasn't it been long-standing established EPA policy and direction to all agency personnel not to give either written or oral assurances to regulated parties that EPA will not take an enforcement action if a violation occurs?
Yes, and Mr. Pruitt's memo directly contradicts a memo dating to the Reagan administration that lays out very specific criteria for no action assurances that he did not follow.
Okay. However, I'm aware that there are cases in which EPA has provided assurances of no action to regulated parties, but these are in special, narrowly tailored circumstances and with limited time periods, often associated with emergencies, such as in the aftermath of a catastrophic storm, like Hurricane Maria, for example. So is that correct?
Yes, they are very short-lived, directed to specific companies, and not broad grants of amnesty like Mr. Pruitt's memo.
All right. So does the DTE Energy case or any other situation described in this memo fit within the narrow circumstances that warrant an enforcement holiday?
It does not fit within EPA's policies.
All right. So, Mr. Wilk, I have another question related to the administrator's December 7th memo. The memo appears to create a new exclusion for emissions increases based on a facility operator's intent to manage emissions increases once a project is completed. Now, how is such emissions management to be measured, if that's the case?
We never know because they don't have to self-report. If it's done after 5 years, EPA cannot enforce. It's completely trusting this source with a promise that EPA will not second-guess whatever they decide.
So if a facility operator intends to manage emissions but then does not manage them, how would this failure be documented? Could EPA enforce this policy?
EPA would never know about it. It won't be documented because the memo doesn't require it. And indeed, EPA will probably never find out about it, and the emissions increases will go uncontrolled.
All right, thank you so much. Thank you, Mr. Chairman.
Gentleman yields back his time. Chair recognizes the gentleman from Texas, Mr. Flores, for 5 minutes.
Thank you, Mr. Chairman. I appreciate the panel and their enlightened testimony today. Mr. Spencer, I'm going to start with you. You support the administration's recent guideline memo on NSR permitting, which clarifies that the EPA will not second-guess a facility pre-construction emissions analysis. And so explain for me, for the committee, what was the problem with the second-guessing and why this memo is helpful for states' work on NSR permitting. Mr. Homestead, I'll follow up with you on this as well.
I think that the clarification was needed, and it doesn't necessarily create a blanket exemption from the responsibility that facilities have. I think that there should be some accountability, such as if there is an error in a calculation that's clear, or if their company has used a wrong significant emission threshold. And so there are backstops for that kind of empirical data to be provided that would ensure that the calculations that have been submitted by the company are, in fact, accurate.
Okay. Mr. Homestead, do you have any additional comments?
Yeah, this whole situation shows that why this program is so broken. Here's what happened. The company used a very sophisticated modeling technique that has been approved by other regulators to estimate its future emissions, and it showed that there wouldn't be an emissions increase. EPA brought an enforcement action, and they said, you didn't do it right. You should use this methodology. The methodology that EPA enforcement officials wanted to use always showed every project would cause an emissions increase. So you have these two different ways of projecting out 5 years into the future, and it's so subjective, and we have so much litigation over it. That's why we just need to use this simple engineering technique of saying, look at what is your hourly emission rate? That's what we do in other programs. That's knowable, that's ascertainable, and instead we have these kind of ridiculous fights. And what makes this particularly ridiculous is that case was brought more than 5 years ago. So we now have 5 years of data showing that the plant actually decreased its emissions. But EPA is insisting that they should have predicted an increase, and we know that whatever EPA turned out to be wrong because emissions have actually gone down.
Okay, that leads me into my next follow-up question for you and Mr. Noe and Mr. Sunday. An important component of the NSR program focuses on how an owner must calculate the anticipated emissions increase associated with a potential project, which determines whether or not an owner is required to obtain an NSR pre-construction permit. So my questions are this: do the NSR program's rules on emission accounting typically result in a calculated emissions value that accurately reflects the true emissions increase? You want to wave off to somebody else?
No, I will just say that there is not an approved EPA method for predicting future, and that's one of the problems. And because every circumstance is so different, and because future emissions depend so much on things that are completely out of the control of the plant owner, it's kind of a fool's errand to be saying that you can predict with accuracy what your emissions are going to be next year and the year after. And we ought not to be putting people in the position to do that. And one of the problems is there is no approved method for doing this.
Now, do you think that the current NSR emissions projections are overestimating the actual change in emissions?
Certainly, the current approach is better than the way it used to work. But again, it creates all kind of uncertainty and problems, and it ought to be fixed.
Okay. Mr. Noy, do the NSR programs, rules on emissions accounting typically result in a calculated emissions value that accurately reflects the true emissions increase? Oh, microphone.
I'm sorry. My sense, Congressman, is no, and we'd like a simpler way to do the math that allows you to move quickly if you don't have a significant emissions increase.
Okay. Mr. Sunday, same question.
No, in general, our facilities are obligated to account for emissions that they're never going to produce.
Okay. All right. I yield back the balance of my time. Thank you.
Gentleman yields back his time. Chair now recognizes the gentleman from California, Mr. McNerney, for 5 minutes.
Well, I thank the chairman. Mr. Walk, sometimes it's hard to see the negative consequences of deregulation, especially if they sound reasonable. In this case, industry recommended that to improve the NSR program, we should allow owners of a facility to avoid the requirements of the NSR program if they improve facility energy efficiency or if they invest in a project for pollution prevention or pollution control, simply on those basis. What's wrong with that argument?
Congressman, you have to look behind the labels. We all support energy efficiency projects that decrease emissions. Mr. McKinley said so. But these energy efficiency projects, the way the label is misused, will allow and result in emissions increases. That's the only way that the new source review requirements apply. The same is true for the pollution control project label. If they just reduced emissions, NSR requirements would not apply. Instead, they increase emissions. So the labels are very important, and the requirements only apply when pollution increases. They do so in both examples that you provided as used by industry.
I think that was pretty clear. Thank you.
Thank you.
Ms. Hammond, it's clear that the Clean Air Act has driven innovation, and the U.S. economy has continued to grow, and innovation has continued to thrive. Is there any evidence that the cost of pollution controls are so high that we've seen massive layoffs and loss of revenue?
The studies that I'm aware of suggest that to the extent companies do have to change their business plans because of Clean Air Act controls, it's not that. It's market conditions that they're responding to. And indeed, that's the case with coal, most certainly. And in fact, with New Source Review, we're often talking about these very old, very dirty coal-fired power plants. And what you don't hear is that in most jurisdictions, these power plants can recover the cost of pollution control technology from their ratepayers. So they're not even asking shareholders to bear those costs.
So is there any evidence that current regulations have caused a reduction in economic growth?
No, and in fact, the opposite is true.
Well, industry claims that the NSR program has stifled innovation and discouraged investment in technologies, new factories, and renovations that would deliver significant benefits. Is there any evidence for that claim?
No, and in fact, pollution control technology is itself a business, and there are many small businesses that benefit from developing those technologies. So you can also add that to the list of more generalized economic benefits that we see.
Geez, you're getting ahead of me. I was going to bring that up. Manufacturing gets left out of the conversation. American domestic manufacturing does get left out of the conversation. Manufacturers that produce pollution control equipment. And a report from 2013 states that the market for these systems was expected to grow to $78 billion a year by 2019. And a 2017 report expects the market to grow to $92 billion by 2022. And more than 75% of that growth is overseas and continues to grow as other countries invest in pollution control equipment. And these are medium to small size private businesses located throughout the country. Would you anticipate the economic impact of these companies and their employees to be if the air quality protections are deregulated and unenforced?
Indeed, they will suffer in that case.
So do you believe, based on facts and economic realities, that there is a choice between environmental control and regulation on the one hand and economic prosperity on the other hand?
No, it's a false choice. They go together. We see over and over again that clean air is good for the economy. It's good for health. People can go to school. They can work. We prosper with clean air.
Okay, Mr. Homestead, I'm going to throw you a bone here. You talked about good regulatory design. What do you mean by that?
I mean trying to find the most effective, the most cost-effective ways of reaching our air pollution goals.
Is there an academic model for good regulatory
Yeah,
design?
there are academic studies that look at all kinds of regulatory programs. And in particular, I will say this, the way we have regulated cars and fuels has been very successful. That's probably been the most successful part of the Clean Air Act. But if you look at these so-called stationary sources, the programs that have been most cost-effective, where we have the highest rates of compliance, are these cap-and-trade programs, where an overall cap is set. That really started with the acid rain program. There's been a number of programs that have built upon that, the NOx-SIP call, the CARE program, CASPER, state programs, and those programs are very cost-effective and very effective at reducing pollution.
So we shouldn't just deregulate everything?
No.
That seems to be what I hear a lot.
No.
Not from you necessarily.
So I think what we need to do is just let's figure out the most cost-effective ways of achieving our air pollution goals. That's what I mean, I agree about all the benefits of reducing air pollution. Let's just do it in the most cost-effective way.
Okay, thank you. I yield back, Mr.
I
Chairman.
apologize to my Republican colleagues for letting my Democrat colleague go so long, but Chair now recognizes gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
Thank you, Mr. Chairman. Thanks to the witness team here as well. I appreciate your involvement. Mr. Noe, you've highlighted a couple of improvements to the NSR and PSD programs in your testimony. Given your description of how broken the program is, are there any other reforms you think are critical to streamlining the permitting process while protecting the environment, which we all agree on?
I think there's a couple I want to mention quickly. First of all, EPA presumes that emissions from multiple projects at a plant over several years should be aggregated when determining significance for NSR applicability. They believe the projects are connected economically if they serve the basic purpose of the plant, even if they incur many years apart, are undertaken for very different business reasons, and by themselves are minor. Once those emissions are added together, NSR can potentially be triggered with its heavy burdens and delays. And we believe EPA should only add together emissions from projects that are truly linked. So that's one example. A second is EPA's PSD modeling guidelines historically have required excessively conservative assumptions about dispersion model inputs that frequently result in gross overestimates of a project's air quality impacts. And regulatory air quality models have the capability to calculate ambient air concentrations based on variable emissions background and modern probabilistic tools and meteorological conditions. So rather than assuming, for example, that the facility is going to be running at maximum levels, all the other nearby sources are going to be running 24/7 at maximum potential level, and that they ought to look at the distributions of the emissions in a probabilistic way. And EPA can address this rapidly developing permit gridlock by having more flexible policies that actually reflect the realistic emissions and the realistic modeling.
Rather than always the worst-case scenario.
Yes, sir.
What other Clean Air Act obligations does the forest products industry face?
You know, we have a whole bunch of regulations that we are covered by. Jeff gave you some examples with power plants. For us, let me just give you some of the major ones. So for hazardous air pollutants, EPA's MACT program has targeted pulp and paper operations, wood product dryers and presses, industrial boilers and coating operations, where emissions have been reduced as much as 92%. For criteria pollutants that are regulated by the NAAQS, those criteria pollutants have been dramatically reduced through regulatory actions such as the NOx-SIP call, regional haze program, and state efforts to implement the NAAQS through state implementation plans. For example, our SO2 emissions are down by over 50% since the year 2000.
Okay. Thank you. Mr. Homestead, You were involved at the EPA in the early 2000s, have, as you said, 3 decades of experience on NSR reform. As a former EPA official, speaking from that experience, why has EPA over the past 28 years had so much difficulty finalizing NSR guidance documents?
Well, I think some of the controversy you've seen here gives you a hint at why that is. But
I'm not egging you on. I'm just
no, but you know, part of the problem here is that this NSR program has become primarily an enforcement program. We refer to it as a permitting program, but when it comes to existing sources, it's become the program where EPA puts almost all of its money when it comes to enforcement. A huge percentage of the budget for EPA enforcement and DOJ enforcement goes to NSR. They love this program because they believe that if they just look long enough, they can find NSR violations wherever they look. And they don't want to give up that weapon. Because if we actually made the program more sensible, so it really was a fair and predictable regulatory program, you wouldn't be able to bring all these lawsuits. And that, I mean, I'm being pretty candid here, but that, I think, is the main reason why we haven't been able to reform the program.
kind of target rich. To the extent court decisions and litigation have contributed to this, what's the cure to ensure regulatory certainty?
Boy, if we could just have some narrow, thoughtful legislative reforms, I mean, that's the best way to take care of it.
To get the job done and do it at least restrictive, but most efficient way.
Yes, sir.
Okay. Thank you. I yield back.
Gentleman's time expired. Chair, and I recognize the gentleman from Texas, Mr. Olson, for 5 minutes.
I thank the chair and welcome to our 6 witnesses. A special welcome to you, Mr. Noe. I'm a fellow paper guy. My dad got a PhD in paper chemistry from the Institute of Paper Chemistry when it was in Appleton, Wisconsin in 1967, a long, long time ago. He spent over 30 years working for Champion International, now became International Paper. He worked at mills in Ohio, North Carolina, Alabama, and Texas. And your association has members all across America. Yes to the members of Region 6, Texas, Arkansas, New Mexico, Oklahoma, and Louisiana, with our new regional administrator, Ann Idsel. And she has already said that she sees major differences between the regions in terms of enforcement of some of these things involving the NSR. My question is, as you deal with EPA's regional differences in the offices, do you see these differences and how they impact your members of your association?
Yes, Congressman, our members do see these differences, and you know, there is unfortunately a lot of confusion with the NSR program. I can't tell you how complicated it is, and honestly, I've literally been in discussions with some of the best lawyers you could find anywhere, and people get into debates, and I've seen examples where none of them can figure it out, and they maybe defer to one in the room. I mean, this is just not how our government should work, where things are that complicated and where the law might be different based not only on what region of the country you're in, but who actually is the person dealing with your permit. That's just not the way a democracy ought to work. That's not the way a good regulatory process would work.
So that there's lots of uncertainty in that process, correct?
Yes, sir.
Another question, a crucial step in any construction project, probably the most crucial step, is to obtain necessary financing, the money. Have your members had a hard time getting project financing due to uncertainty, like multiple standards in multiple regions of the EPA and time delays caused by the NSR process?
I think any time there's regulatory uncertainty, that creates business uncertainty, it creates risk, so it does impede projects from going forward.
Mr. Sunday, how about you? Difficulty getting permitting process with all the financial stuff as well?
Yes, if you're going into the debt markets or to do private financing, the lender's not going to give the revenue or capital until all appeals are settled. And so what we've seen is perpetual litigation by third-party groups where the permit goes through the process, there's a challenge, they go through the court, now the universe of controls is different. Lender's still not giving the capital. We go through the litigation again. So it really hangs up the process because we can't get a clear path to yes.
One question for you, Mr. Spencer. In your testimony, you described some of the issues with the NSR in terms of enforcement. Specifically, you said, and I quote this, "It's important to reorient policies toward pursuit of actual violations that create emissions increases," end quote. I assume the NSR was involved with pursuing actual violations. And you say we have to reorient that process. Can you explain that more, elaborate on why you made that statement?
Yes, thank you, Congressman. I've been dying to say bizarre NSR all day long, so I got that into the record. I wrote down a few phrases here: unintended consequences, perverse incentives, absurd results. And those are terms I've heard more in my practice with Clean Air Act regulations and enforcement than I've heard in my entire career. And so I think what you're looking at is something that Mr. Homestead alluded to earlier, when you have a facility that has engaged in a emissions projection, but the reality of the situation is that time has advanced since that projection was made, and there has been no actual increase. And so as a state regulator, when we exercise our enforcement ability, we are looking for actual events, actual emission violation events.
One final question. From your perspective, does EPA's memo of December 7th improve the reorientation of the NSR? Is that what you tried to do? I'm sorry, the NSR.
Yes, I would agree with that.
Okay. And Mr. Chairman, I yield back the balance of my time.
Gentleman yields back. Chair, and I recognize the gentleman from Georgia, Mr. Carter, for 5 minutes.
Thank you, Mr. Chairman. Mr. Noley, I too, I grew up in the South where paper mills are plentiful. In fact, my dad worked in a paper mill. He didn't have a degree. He was just a laborer. He worked in a paper mill for over 35 years. And the best thing he ever did for me after my freshman year in college was to put me to work on a broke beater. You know what a broke beater is?
I'm not sure.
Well, it's at the end of the process. It's where all the excess paper
The
goes.
broke
and you,
comes out.
Yeah, and you just take it and you assemble it and you put it back and then you recycle it, per se. But I can tell you that it was as close to hell as I've ever been. I have never been that close. But I could not get to school quick enough. I could not get back to school and study hard quick enough, I will tell you that. It was a life lesson. Air quality was important to us. People would visit us and they'd say, "What's that smell?" And we'd say, that's money you smell," because that's what it was for us. But it is important, and I understand that. But I want to try to understand. Tell me what project netting is. What essentially is that?
So basically what we want to make sure we have is a system when we do the math and we look at a project to see if it results in a significant emissions increase. If it does, then by all means, let's go through the heightened scrutiny. Let's put on best controls if that's indeed the case. But when we do the math, let's look at the increases and decreases together so we don't wind up getting the project gummed up in the works, delayed, spend hundreds of thousands of dollars on consultant studies just to get to the obvious answer that when there's not a real significant emissions increase, we should be putting this into NSR. We ought to go forward with the project, and because these are beneficial projects. And one point I'd like to make is, I think one thing that's being lost is when a regulatory program inhibits efficiency improvements at one facility, it's doing that all around the country for a bunch of them. So when we have demand X to meet, we're going to do it as a nation in a more inefficient and higher polluting way. When we can get these efficiency improvements in, by nature, we're going to have not only less CO2, but other pollutants as well.
Okay, I've heard the process. Tell me how we reform the process. Tell me what we do differently from what we're doing now that makes it practical and sensible, because that's what we all want to get to.
Sure, and some of the things I've mentioned, these are things EPA can do either through guidance or through rulemaking. There are some things Congress can do. Mr. Homestead mentioned some of them. Ones I would like to highlight is we would like to ensure that clean units have legislative support. So in other words, an emission unit that's been through the permitting process to have best controls put on it, that ought to be only an increase in the unit's permitted allowable emissions would trigger NSR. For pollution control projects, those need legislative support, and they're excluded under the New Source Performance Standards program. It makes sense to do the same thing in the NSR program, we believe.
Great, great. Well, Mr. Nolley, I want to thank you, and I want to thank you for what the paper industry did for me and for my family. It provided us a living.
Well, Congressman, if I could just briefly thank you and Mr. Olson, and I'm glad to hear you have a connection to the industry. Our workers are up here visiting many of your offices
Yes, they
this
are.
week. I hope you get to meet them. And you know these are very proud, hardworking people.
Absolutely.
And they're not asking for anything from any of you other than the right to compete in this country. They can beat anyone in the world as long as they are given a playing field that's workable. No one's here asking you to take controls off projects that ought to have emissions controls. We just don't want the delay and the unnecessary red tape that is gumming up our modernization.
Thank you, Mr. Nolley. Mr. Chairman, I yield back.
Gentleman yields back his time, and the chair now recognizes the gentleman, if he's ready, the gentleman from Texas. Do you want me to go to? All right, gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I'm thanking you and the ranking member for holding the hearing today on the New Source Review. And I'd also like to thank our panelists. I come from an area, a very urban area in Houston, that we have issues. We have 5 refineries and more chemical plants than I can count. This is a question for, I think, everyone on there. Many stakeholders have noted that the substantial delays for air permits under the New Source Review program delays 2 years or even longer. My question is, are the delays for issuing the permits the fault, or the EPA or the state agencies that are administering the program?
Since I'm with the state agency, I'm going to say it's EPA's fault. No, I think that as we've indicated in our testimony, certainty adds to the process of being able to issue timely permits. So the more certainty we have, and clearing up the muddied guidance documents, applicability determinations, court cases, the better and more efficient permits we can issue.
Anybody else?
We'd like to say, Congressman, what we'd like to see happen to streamline the process is just make sure that we get sort the wheat from the chaff. The truly significant projects with significant increases ought to go through NSR. They ought to put on controls. But for these minor projects, why gum them up in the works with these consultant studies that take all this time and money and delaying these projects from going forward? So we'd like to streamline the process. I believe EPA could do that.
Congressman, the permits in this country are issued primarily and overwhelmingly by the states. Yeah. And it's frankly a lack of resources and capacity at the state level that's responsible for most of the permitting delays. There's a good Houston Chronicle article about a week or two ago in which a Texas regulator said exactly that about issuing air permits in Texas. Now, the Trump administration yesterday just proposed a 33% cut to the state and tribal air grants, which are the monies from Congress responsible for issuing permits in a timely fashion. So we got cross purposes here, and I expect that our friends at APCA and the National Association of Clean Air Agencies would like to see Congress fully fund them so they can issue permits on time. We all want to see that.
Okay. I was involved in a permit a few years ago because right now we're seeing in East Harris County, particularly along the Gulf Coast, expansion of chemical plants just because of the low price of natural gas, and the delay in the permits were combination. And I would call EPA and say, okay, tell me what's going on. It was for ExxonMobil in Baytown, huge expansion of their chemical facility, jobs and everything else. And so sometimes it's both sides. It's both the feds and, because in that case, it delayed it a little bit because there was I didn't know the EPA, Mr. Chairman, had an appeals process within their agency. And when I was told by the deputy EPA administrator, he said, oh, well, we got a good result. I mean, we got a good brief and it'll go to this group. I said, well, who are they? I want to do a letter to them. And she said, oh, and he said, oh, no, they're all EPA administrator. I said, well, how long will that happen? And he said, it'll take a few months, and it took 6 months to get through that EPA appeals board. So, which didn't do anything to it, just delayed it 6 months. So. Anyway, why are there long waits for air permits in industry-friendly states like Texas Could delays from the state agencies be a result of the budget cuts? And I think you answered that. Earlier this week, President Trump's 2019 budget proposed 25% cut in EPA and reducing EPA's workforce by over 3,000 employees. And I think it's already answered that if you believe these cuts in EPA will improve air permitting times, I don't know if you can do it with less, do it faster with less people. Is that possible?
I don't see how it's humanly possible. And you're right that it's EPA and states contributing, and the Trump budget proposes cuts to both.
Okay. Thank you, Mr. Chairman. I yield back.
Gentleman yields back his time. Chair now recognizes very patient, although he's not a member of the subcommittee, Mr. Griffith, for 5 minutes.
Mr. Chairman, I'm just very appreciative to be here as we discuss this issue, which is very near and dear to my heart. I will say that I appreciated somebody saying that what we need is narrow, thoughtful regulatory reform. I believe that was you, Mr. Homestead, and I am attempting that with my bills and open to suggestions. And, you know, I'm looking in my file here at all kinds of changes and rewrites and so forth, and that's what we're trying to do, is just have a narrow, thoughtful regulatory reform that works right. And it comes about because, as some people say, you know, there's a lot of people out there that want to see this thing work. We all want clean air. Mr. No mentioned his industry. They were out in the hallway. I had to step out right at the beginning just to say hi, because I have probably a couple thousand employees at West Rock at 2 different facilities in my district, and it's important. Likewise, I thought we touched on maybe part of the problem in Ms. Hammond's comments earlier when she was talking about putting on controls at coal-fired power plants, and she said the plants can, the agencies or the power companies can pass, and I hope I get it right, but it's pretty close, can pass the cost on to the ratepayers so it doesn't cost their shareholders anything. Well, that's the problem. It's the ratepayers who get it. And so I've received, I thought it was interesting, exactly 2 weeks ago, I received a series of texts from a friend of mine in the district, and it said, just opened my AEP bill. She gives me the numbers, and I calculated 70% higher than what she said her highest bill was last year. She goes on to say, we can handle it, but many are suffering. Do you think we can get it turned around? Big subject on Facebook. Everyone is panicking. So when we do regulations that, you know, maybe it doesn't affect the shareholder, but most of my constituents in Southwest Virginia aren't shareholders. They're ratepayers. And it's easy to sit here in Washington where people have big incomes and say, well, we're just going to pass this on to the ratepayer. But when you're dealing with a lot of folks who have modest means, we can handle it. I can handle it. This lady who wrote me can handle it. But many in my district are suffering, and we have to come up with reasonable reform that makes sense, where we don't open up for pollution, but we do make sense. And I'm going to give you another example. I've got a furniture manufacturer in my district, and I haven't been there in a couple of years now, so maybe they fixed it somehow. But Mr. No mentioned earlier about the confusion on the law, and he had a loop in his conveyor belt that was about half the size of this room, and there was nothing there. It was just a big loop. And he said, I bet you wonder why we have that. And I said, yes, I do. And he said, it's because if we change this was once a part of our paint system, and if we change it, we have to get permission from the EPA in advance. So we built these ramps to go over it, and we just leave it there, and it just runs off here into the middle of nowhere and back. That's what we're trying to fix. It is, you know, that's the one I can understand best. Some of you all can talk about all the different controls and different improvements at the big power plants. But I know that it also deals with things like conveyor belts, and the end result, if we don't get it right, and we haven't, is a 70% increase in the people back home having to pay for their electricity. All right, got that off my chest. I appreciate y'all's patience on that. I do think that we can work together to get this done. Mr. Homestead, you had some concerns that you raised earlier, and I understand in the written testimony that Mr. Walke claims that when you were the head of the EPA Air Office back in 2002, the Bush administration weakened the clean air regulations at issue here to insert loopholes and exemptions that let industry increase harmful air pollutants significantly and evade any modern pollution controls. Would you like to respond?
Thank you. What you just read indicates part of the problem here. And just in terms of the honesty of the debate, So that was a quote from my friend's testimony, who said that the Bush administration weakened them to insert loopholes and exemptions that let industry increase harmful pollution significantly and evade any modern pollution controls. I don't know how anyone can say that. That was 2002. You go on EPA's website, you do a search, and you see where emissions have gone since 2002, and all of these pollutants that we're talking about have been reduced by about 35% since 2002. So we did do some important reforms that I think made the program better. We didn't let industry increase harmful pollution significantly. We try to do things in a thoughtful way, and that's part of the problem here.
And I appreciate that, and I appreciate the opportunity to be with you all today, and appreciate everybody's testimony. And what I appreciate most is the two of you who completely disagree, Mr. Homestead and Mr. Walke, are sitting side by side, and that's the way it's supposed to be in America. We can disagree, we can have battles of ideas, but we don't have to be completely disagreeable or get so angry that we can't sit at the table together. Thank you for that, and appreciate your testimony. Yield back.
Gentleman yields back this time. Seeing no further members wishing to ask questions for the first panel, I'd like to thank you all for being here and joining us today. Before we conclude, I would like to ask unanimous consent to submit the following documents for the record. We have a letter on the EPA's NSR program. We have this article, EPA's New Source Review Program, Time for Reform, Art Frass, John Graham, and a guy named Jeff Homestead. And oh, so we got that. In pursuant to committee rules, I remind members they have 10 business days to submit additional questions for the record. I ask the witnesses to submit their responses within 10 business days upon receipt of the questions. Without objection, the subcommittee is adjourned, and I would encourage my colleagues to get downstairs for our markup.